Welcome to the Depth Dive. Today we're stepping back into the late Roman Republic, right into the Forum, actually. It was this incredibly intense place where legal battles weren't just about winning a case. Sometimes it was life or death, or even deciding Rome's political future.
Exactly. And our focus is Marcus Tullius Cicero, the famous orator, the advocate.
Yeah, the man whose rhetorical skill really defined what it meant to be a Roman lawyer.
And when you look at Cicero, you're not just seeing a lawyer. You're seeing this nexus of law, politics, power. It's all intertwined.
So our mission today is to sort of unpack that legal landscape he worked in. It was sophisticated, sure, but also full of contradictions.
Right. And while, we don't have exact transcripts of his big trials, think Sextus Roscius or the prosecution of Vera as our sources, the fragments we have, they give us something else.
Something maybe more valuable.
Arguably, yes, a way to reconstruct the legal system itself, the social biases, the whole professional and personal world that produced someone like him.
Okay, so we've got these legal fragments, juristic writings, and crucially, Cicero's own letters. His correspondence gives us this amazing personal insight.
Yeah, they're invaluable.
So we're going to piece together this picture of Rome's legal world using all these different sources. Let's start with maybe the most fundamental tool for any Roman advocate: persuasion. The art of rhetoric.
Mm-hmm. For an advocate in Rome, you couldn't really separate law from rhetoric. Of course, you had to know the statutes, the procedures, but your real weapon, that was your ability to persuade, to move an audience.
It sounds like performance was key.
Oh, absolutely. Roman court was, in many ways, theater. You weren't just talking to a judge. You often had a large panel of judges, plus the crowd, the public watching. You had to sway them all.
And Cicero was apparently the best at this. Pliny the Younger, writing, decades later?
Yeah, quite a bit later.
He talked about Cicero's style having a lavish coloring. I find that phrase fascinating.
It really is. It suggests, richness, decoration, maybe digressions, really ornate language, dramatic moments, even when he wasn't sticking strictly to the legal facts.
So pulling the argument off the main path wasn't necessarily a bad thing.
Not if it worked. It implies that the sheer entertainment value, the dramatic force, was part of the strategy. Cicero knew that a bored jury, or a confused one, well, that's dangerous.
Right, keep them engaged.
Exactly. The rhetoric provided maybe some light relief, built an emotional bond, let the advocate shape this kind of moral atmosphere around their client, even if the pure legal arguments were maybe a bit shaky.
So the persuasive power was huge. If the law itself is complex, maybe open to interpretation,
Then the most compelling speaker can basically define the truth for that moment. Yes.
that's a really key point. The advocate had to manage the audience's psychology just as much as the legal code. But what's great about our sources, especially the letters, is we get to peek behind that performance.
Yes. The letters are just fantastic for that. They give us this raw, sometimes vulnerable look at the reality behind the public figure.
They provide that crucial emotional context, don't they? When Cicero is dealing with these huge political crises, navigating Julius Caesar, the Civil War looming.
His letters show that those massive public things were completely tangled up with his everyday personal worries. They weren't separate compartments.
It's almost jarring sometimes how the big historical events just crash into the mundane details of his life.
It really is. You see him worrying constantly about money, about finances, negotiating dowries, marriages, not just his daughter's, but his own too, dealing with his own divorce, which was difficult.
And then there's tracking down runaway slaves who'd taken valuable things.
Yes. And grieving for loved ones, complaining about his health. There's mentions of an upset stomach after some dinner party.
And the statues. We have to mention the statues.
Yes. The endless quest for Greek statues for his villas. It sounds almost funny, but it wasn't just about decoration, was it?
No, it was part of maintaining that image, the status required for a man in his position.
Precisely. So the point is, the guy standing up in the forum, delivering these powerful speeches, he's also juggling all this chronic personal anxiety, financial stress, family problems, health issues.
And he had to maintain that performance regardless, whether his digestion was off or not.
Exactly. That performance couldn't slip.
It just paints this picture of incredible, constant stress. And in that kind of environment, even someone who'd reached the top, like Cicero, was always legally vulnerable, weren't they?
Absolutely. Political crises weren't just things happening out there. They could become legal precedents almost overnight.
That instability is key to understanding his world. You mentioned the Catilinarian conspiracy. Cicero was right in the middle of that.
He was. And sources mention a woman, Fulvia, who apparently helped expose the plot. Years later, the jurist Papinian actually used her role in that very political event.
To argue for a general legal right.
Yes, to argue that women could bring accusations in cases of maesta's treason. So you see this direct link.
Political chaos happens, there's a need for some kind of justice, and that pressure bends the existing legal rules.
Exactly. In this case, maybe empowering women in a specific way, creating a new precedent that lasted. The legal system wasn't static at all.
It reacted to politics.
Highly reactive, shaped by immediate needs, often by the ruling class trying to crush their opponents.
Yeah.
So an advocate like Cicero had to know the rules, yes, but also guess how the next political earthquake might just rewrite them. That's the tension he lived with.
Okay, so we have this volatile political backdrop. But if the law was so susceptible to politics and rhetoric, what were the actual rules? What was the legal framework Cicero was working with?
Right. To really appreciate a master strategist like him, you need to understand the foundations. Roman law was layered, complex, somehow both rigid and flexible.
Let's start at the bottom. The bedrock was the Idonus Civil, the old civil law.
That's the one. The original law of Rome coming from ancient customs, sometimes written down like in the 12 tables. Very old, very Roman.
And very specific to Roman citizens, I gather.
Yes, and notoriously formal. You had to use the exact right words, perform the exact right rituals in court or for contracts, miss one step, and your whole case could just fail.
Wow. Sounds tough.
It was great for tradition, for defining who is a citizen, but really not suited for the complex reality of a huge, growing empire with lots of trade and foreigners.
Which is where the other layers come in, like the indisgentium, the law of peoples.
Exactly. That grew out of necessity. Think of it as like ancient international commercial law.
How did it develop?
Through magistrates, especially the praetor, dealing with cases involving non-Romans, traders, allies, people living in Rome who weren't citizens. They couldn't use the India civils ritual.
So they needed different principles.
Right. Principles based more on, good faith, reason, things that seemed fair to everyone involved. That flexibility was vital for Rome's economy.
But the real game changer, the thing that allowed the law to adapt most effectively, was the indus honorarium, wasn't it? The law made by magistrates through their edicts.
Absolutely. The praetor, in particular, was the legal innovator. Every year, the praetor issued an edict outlining the legal principles and remedies he would apply during his term.
So if a case came up where the old Idris civil seemed too harsh, or maybe it was a totally new kind of problem?
The praetor could essentially create a solution in his edict. He didn't technically overturn the old law, but he'd offer procedural tools, new types of lawsuits, defenses that allowed judges to reach a fair outcome.
So it was like adding patches or workarounds to the old system.
That's a good way to put it. It provided this crucial flexibility, filling the gaps, softening the edges of the rigid civil law. Cicero would have been navigating this constantly.
Now, thinking about where laws actually came from during Cicero's time and just after, there was a big shift happening, right, with the Senate.
A huge shift. Under the Republic, the Senate was mainly advisory, focused on things like foreign policy. It didn't really legislate in the way we think of it.
But that changed with Augustus and the move towards empire.
Completely. Senatus consulted decrees of the Senate suddenly became a really major source of new law. Often, the emperor would propose something.
And the Senate, which is becoming more of a rubber stamp anyway.
Would pass it, yeah. So legislative power effectively shifted away from the old popular assemblies and concentrated much more towards the emperor and the Senate acting on his behalf. It led to rapid legal development, but also centralization.
Okay, let's talk procedure. If Cicero is arguing a criminal case, maybe out in the provinces, who had the ultimate say, the absolute power?
That power rested almost entirely with the magistrate holding imperium, usually the proconsul, the governor.
Imperium, that's the key term.
It is. The proconsul was the sovereign legal authority there. His imperium gave him the power for criminal jurisdiction. The sources use terms like coercer, meaning coercion, and animadvertere, punishment.
Could he delegate that power to a lower official?
The sources are really clear on this, no.
Yeah.
That core criminal jurisdiction, especially capital punishment, could not be delegated. The proconsul himself had to exercise it.
Which explains why getting a provincial governorship was such a big deal politically.
Absolutely. It came with almost total discretion over life and death in criminal matters. That's real power.
Switching back to civil law for a moment, the idea of pacts or agreements seems quite nuanced. They weren't just side notes to contracts.
No, they could actively change the deal. For instance, you could have a pact where a creditor agrees not to sue a debtor. That was considered valid.
Really?
Yeah. Or they could agree to only sue the debtor up to the limit of what the debtor actually had, sort of like an early form of limited liability agreed up front.
That's surprisingly flexible.
It is, and
Yeah.
pacts could even be used to undo parts of a contract. Like, you could agree to partially cancel a sale just by mutual agreement later on. It shows quite a bit of freedom in contracting.
But the praetor would only enforce these pacts if they were made in good faith, right? Not maliciously.
Correct. They wouldn't enforce a pact made maliciously, dolo malo, or one that went against statutes or the praetor's own edict.
And how did they define malice in this context?
Dolus, or malice, was seen as craftiness, deceit. The definition was something like pretending one thing while intending another for the purpose of cheating someone. It was about getting behind the words to the fraudulent intent.
So a good advocate needed to expose that hidden intent.
Exactly. That was often where the skill lay, proving the dolus.
We also get glimpses into how contracts started out. Early Roman real contracts, the ones involving physical things like storing something for a friend, depositum, or a simple loan, they had this specific requirement.
They had to be gratuitous, meaning no fee could be charged. This goes back to that old idea of noblesse oblige, the duty of upper-class Romans to help out friends and neighbors without expecting payment for these basic services.
So if I agreed to look after my friend's stuff while he traveled, but I charged him a small fee for the trouble.
Legally, it instantly stopped being depositum. It transformed into locatio conductio letting and hiring.
And that mattered.
Oh, yes. It changed the legal responsibilities, the standard of care required, what remedies were available if something went wrong. It shows how much those formal categories mattered in the Ingius Civil.
Speaking of formality, there's the stipulatio, the verbal contract. It sounds incredibly simple. Titius asked, Mavius promised.
Simple words, huge legal weight. That phrase was basically the magic formula.
How so?
The sources tell us that if a pact or agreement included that specific phrasing, so-and-so asked, so-and-so promised,
Yeah.
it was automatically understood that a formal, legally binding stipulatio had taken place.
Automatically.
Unless they explicitly said otherwise, yes. Just including those words meant an action on stipulation arose. It created an enforceable obligation right there. It really highlights the power of getting the exact verbal formula right in Roman law.
We've built up this picture of a sophisticated legal system, flexible edicts, formal stipulations, but now we need to confront maybe the biggest contradiction, the huge gap between the legal theory and the everyday reality of social status.
That gap is absolutely fundamental to understanding Cicero's world. Roman society was obsessed with hierarchy, and the sources make it plain. Respect for status showed up much more in how officials acted than in the abstract legal rules.
So practical discrimination.
Yes, endemic institutionalized discrimination, both in civil and criminal courts.
In theory, the legal system, the formulary system, was supposed to be neutral. A poor person should have been able to sue a rich, powerful person.
That was the theory. But the reality, our sources suggest that for a low-status person, just summoning a high-status defendant, let alone actually enforcing a judgment against them, was often practically impossible.
So de facto inequality.
Completely. Think about the social pressure, the intimidation, just the sheer difficulty for an ordinary person to navigate the system against someone with connections and influence. The law might have looked equal on paper, but the enforcement wasn't.
And this showed up in actual legal rules too, didn't it? Restrictions on who could even bring a lawsuit.
Yes, there were rules specifically designed to protect the social hierarchy. For example, a son or a freedman couldn't easily bring an action against their father or patron if that lawsuit carried the penalty of infamia.
Infamia, that was the loss of legal standing, reputation.
Exactly, a devastating social and civil penalty. So the law actively shielded the heads of families and patrons from potentially damaging attacks by those lower down in the structure. It reinforced that social order.
And this protection wasn't just within the family. It shielded the elite, generally.
It did. The sources say that lawsuits were often discouraged or even flat out denied if a person of low status tried to sue someone preeminent in status, a commoner trying to sue a former consul.
Right.
It was about preserving the dignity, the dignitas of the elite. That was often seen as more important than giving equal legal access to everyone. If you were Cicero defending a high-status client, their sheer social weight was part of your defense.
The most chilling aspect of this has to be the punishments, especially when judges went extra ordinum, outside the normal procedures.
That's where the discretion became terrifying. When proceeding extra ordinum, a judge had immense power. They could basically impose any penalty they wanted on a defendant.
Any penalty?
As long as that defendant, even if technically a free citizen, was considered of humble status. Humiliores, they were called. These proceedings bypassed the usual legal protections for citizens.
So a poor free man could face punishments usually reserved for slaves.
That's exactly what happened. We see this clear historical trend. Penalties like torture or particularly brutal methods of execution, which were originally meant only for slaves, started being applied more and more to these lower status free citizens.
Wow.
That merging of punishments is maybe the starkest evidence of how deeply status discrimination ran in the justice system.
And the reverse was true, too. Hurting a senator was treated much more seriously.
Much more seriously. If an injury in iuria was committed against a senator by someone of humble status, ob humili persona, the crime was automatically classed as atrox outrageous,
And atrox
a much harsher penalty. The severity wasn't just based on the act itself, but on the status difference between the people involved. Cicero, defending someone accused of harming a senator, knew he was facing an uphill battle from the start.
Finally, we can't ignore slavery. It was so deeply woven into Roman life and law. Cicero would have dealt with slave-related cases all the time.
Constantly. The law around slavery was incredibly detailed. There were specific ways to gain freedom, like formal manumission before a magistrate. That usually granted Roman citizenship, which was rarely lost.
But freedom could also be conditional, written into wills, for example.
Yes, quite often. There's a specific example in the sources. A master buys a slave with a condition that if the master makes the slave his heir in his will, the slave will be freed. If that happened, the slave gained his freedom.
It shows the law recognized slaves could be part of these complex future arrangements.
It does. And masters also use contracts to protect their investment in slaves.
How did that work?
Well, if a master loaned out a slave or deposited him somewhere for safekeeping, the contract might include a specific pact. The recipient would promise not to neglect the slave in a way that let him become a thief or promise not to help him run away.
So, clauses defining liability for the slave's behavior.
Exactly. It shows how carefully Roman law treated slaves as valuable, but also potentially problematic property, defining who was responsible if the asset misbehaved or disappeared.
We even have some fascinating numbers about where slaves came from in Cicero's era.
We do, and it's quite revealing. It seems homeborn slaves, oikogenes or endogenes, made up a really high percentage. Something like 44% of those freed between 153 and 100 BC were born into slavery in Roman households.
So it wasn't all just captives from wars?
No. It strongly suggests that domestic reproduction, slaves having children within Roman households, was a major source of the slave population in the late Republic and early Empire. It was a self-sustaining system, embedding slavery even deeper into Roman society and law.
Okay, we've looked at the practice of law, the rhetoric, the rules, the discrimination. But what about Cicero's own philosophy? What ethical compass guided him through all this? We find clues in his work on duties.
Deficies, yes. It's Cicero wrestling with that core problem of public life. The clash between what's honorable, the honestum, and what's merely useful or expedient, the utile.
He followed the Peripatetics, Aristotle's school.
Broadly, yes. He stressed that the honorable should always come first. But crucially, he wasn't naive. He acknowledged that in the real world, the two often conflict, and you need a practical way to think about it.
And he identified 3 ways they interact. This was his practical guide.
That's right. He said, 1, sometimes what's honorable is also useful. 2, sometimes just the appearance of being honorable is necessary for success politically or legally. And 3, sometimes sheer necessity forces you to do things that are useful but maybe not inherently honorable.
That sounds like a recognition of the messy reality of politics.
It absolutely is. A recognition that survival sometimes requires compromise.
The example he uses, contrasting wasteful spending with necessary spending, really drives this home, I think.
It's a great example. He frowned on things like extravagant feasts or public games, saw them as not really honorable uses of wealth. But then he cites Aristotle's point about necessity.
The story about the besieged city.
Exactly. If people in a besieged city are forced to pay an insane amount, a mina, for just a pint of water, well, that seems wasteful in normal times. But necessity makes it completely understandable, even justifiable.
So extreme circumstances can change the ethical calculation.
Precisely. And that connects to how an advocate might have to operate in a high-stakes political trial. Survival might trump pure idealism. Cicero argued that money was better spent honorably ransoming captives, helping friends with debts, providing dowries, things that built social capital, not just personal luxury.
What's really interesting is how Cicero's influence lasted. He wasn't just remembered for his philosophy. Later jurists actually cited him on points of law and history.
His footprint is definitely there, centuries later. We even see him referenced on things like the legal status of towns. He called his own birthplace Tusculum Municipium and Equissimum, the most ancient municipality.
And that was used in legal arguments.
Yes, cited as evidence about his legal rights and status before Sulla made big constitutional changes. So he became an authority on historical civic law.
And even his personal letters, the ones we talked about with the statues and the stomach aches, they ended up being used for technical legal research.
It's one of the most amazing details. Jurists centuries later were trying to figure out complex bureaucratic timelines like, could someone have been a quaestor, then a legate 14 years later, then a praetor? Or figuring out the exact career path of someone who was quaestor in 45 BC and legate in 46 BC.
Really specific, dry, administrative questions.
Very dry. And how did they try to solve them?
Cicero's letters.
They turned to Cicero's letters, especially the ones to his friend Atticus. Those personal notes, full of gossip and complaints, also contain the precise dates and details of who held which office when.
So his private life became a public record for sorting out Roman bureaucracy.
Incredible, isn't it? The man worrying about his villa decorations inadvertently left the key to verifying the technical structure of Roman political careers.
It just cements his central role, doesn't it? Even his anxieties became historical sources.
It really does. His private life became tangled up with validating the historical reality of the very system he fought so hard to understand, to master, and ultimately the republic he tried to save.
So this deep dive really shows, I think, that you don't need the courtroom transcripts of Pro Rocio Marino to grasp Cicero's world. When you look at the environment, the need for that lavish coloring and rhetoric, the intense personal pressures alongside the political crises, the sophisticated but deeply biased legal system.
You get a real sense of the crucible he was forged in.
Yeah, you see him as this figure of immense rhetorical and legal skill, but also as a human being caught in the cross-currents of money, family, politics, the very things shaping the laws he argued about.
His career is a powerful reminder. Roman law had intellectual depth, sure, but mastering it in practice, that was the highest calling, the most demanding job in Rome. It took legal brains, yes, but also political smarts and a constant performance.
We've seen how Rome relied on these complex legal frameworks, the Civis Civil, the Iumius Honorarium, but we also saw how on the ground, status and connections could just sweep those principles aside.
Which brings us back to Cicero's point about the appearance of honorableness sometimes being necessary.
Exactly. So we'll leave you with this to think about. Given that pervasive inequality, that de facto bias, and the vulnerability of even the greatest advocates like Cicero, how much of the rule of law we see in the late Republic was about genuine legal principle?
And how much was really about the supreme skill, the art, of convincing the judges, the jury, the public, that your powerful client simply deserved the benefit of the doubt, deserved to be seen as honorable, regardless of the facts?